Good evening, everyone. For those of you who don't know me, I'm Yvette Moy, and I'm the University of Washington's Director of Public Lectures, and thank you for joining us tonight for our 15th and final lecture of the academic year. We're feeling pretty proud about that. For those of you who would like to come to public lectures next year, just know that we will be opening our lineup and sharing that around August 1st. And if you want to know who we're hosting, sign up for our socials. You'll find us on Facebook and Instagram, UW Public Lectures. And tonight, it is with great pleasure that we welcome the judge in the Kenyan Court of Appeal and chair of the Kenyan National Steering Committee for the implementation of the Alternative Justice Systems Policy, as well as a member of the University of Washington School of Law, the Honorable Judge Ngugi. Before we begin, I'd like to acknowledge and thank a few people who helped us bring Judge Ngugi to the University of Washington, and it's the UW's Department of History, the School of Law, the Jackson School of International Studies, and the African Studies program. If anybody's from these, you guys can give a little shout out to yourselves. That's all right. We get to celebrate the Department of Political Science, the Evans School of Public Policy and Government, my alma mater. Go Evans School. And I also want to thank the University of Washington staff and friends who were voluntold to help us this evening. I'm just so grateful for everybody. We have a few housekeeping items to go through. If you haven't done this already, please take out your cell phone and silence it, or just turn it off. We ask that you refrain from video or audio recording this evening's lecture. We are live streaming this lecture, and it is being recorded, and you'll be able to find it on the University of Washington's Public Lectures YouTube page about 24 to 48 hours after the lecture. We also ask that you not take photographs while our speaker is on stage. You will see our student assistant, Yaz, who is doing work for social media for us, floating in and out, but he's pretty quiet and fairly discreet. This evening, there are two ways that you can ask questions. You can do it old school by coming to the microphone over here, stage right, and asking your question in the form of a question. That's right, you heard that. And also, you can send them in via Slido. There's a QR code that usually shows, but I don't know where it is, tonight. So you can send that in as well. We'll get that up in a minute. And then tonight, just so you know, we have a slight technical issue. We do not have cart captioning due to some technical problems that we're encountering. So I apologize for anybody who needs that. I am really sorry. We try really hard, but sometimes these things happen. And this evening, Judge Ngugi will be introduced this evening by the University of Washington's Giovanni and Omni Costigan Endowed Professor in History, Dr. Lynn Thomas. And as Dr. Thomas is making her way to the stage, I invite you to take a minute to say hello to the people sitting near you and introduce yourself. Make a new friend tonight.
All right, good evening, everybody. Good evening. As Yvette said, I am Dr. Lynn Thomas. I am a member of the History Department, a faculty member, and I have the honor of calling Judge Ngugi an old friend and a colleague. So we met 20 years ago when he joined the University of Washington as a professor in the law school. Most recently, he came and spoke in my Introduction to African History class on Monday, where he absolutely wowed the students with his wit and his charm and with his incredible insight into both Kenyan politics as well as US politics. And I'm sure he'll do the same this evening for all of us here. So Dr. Joel Ngugi is a distinguished Kenyan legal scholar and a judge. He earned his Bachelor of Law degree from the University of Nairobi in 1996. And as a student, he was also the president of the Kenyan Law Student Society. After graduating from the University of Nairobi, he practiced law for 2 years, and then he came to the US to pursue his graduate studies at Harvard Law School. There he earned his LLM and his SJD. At Harvard, he also co-won the John Gallup Leyland Prize in International Law, and he served as a legal officer for the UN in Kosovo and a research associate at the World Bank. Then in 2004, Dr. Ngugi joined the University of Washington Law School, and there he earned multiple awards. In his very first year teaching, he won the Best Teaching Award, and that was the first of many that came his way. He also published extensively on international law and development. He also, in his time at UW, chaired our program of African Studies in the Jackson School. And he led some really memorable study abroad programs to Kenya for both graduate students and undergraduates. And I think we have some alum from those programs here with us tonight, which is wonderful. So as some of you know, in 2010, Kenyans, by popular vote, by a popular referendum, adopted one of the most progressive constitutions in the world, really. And the year following that, Dr. Ngugi was recruited to come back to Kenya to be part of the judiciary that would then interpret and bring that constitution to life. So he joined the judiciary as a high court judge, and then in 2002, he became a judge on the Court of Appeal. In those roles, he has championed judicial transformation, alternative justice systems, and constitutional integrity. He has served as head of the Judiciary Transformation Secretariat and director of the Kenyan Judiciary Academy. And in 2021, he authored what has come to be known as the Building Bridges Initiative decision, or the BBI decision. And this decision is a landmark ruling against executive overreach. And this is an incredibly important decision that I think will be studied for years in law schools, not just in Kenya or elsewhere in Africa, but also a decision that should be studied in places like the US, where, of course, issues of presidential power and overreach are really at the center of our national politics today. So for all of these judicial contributions, Dr. Ngugi was named Kenya's Jurist of the Year in 2022. And just last year in 2024, Transparency International honored him with its National Integrity Award. Ever humble, Dr. Ngugi accepted the Jurist of the Year award by saying the following: "This is not my award. It is an award for the ordinary Kenyan who defends the Constitution and lives its ideals every day without even mentioning it by name. I'm just their go-between." Please join me in welcoming Judge Ngugi to the stage.
A lot of lights. Good evening. You know, in Kenya, when you say good evening, you expect everybody to say good evening back, with only two exceptions. If you're my enemy, you don't say good evening back, or if you're a witch. So I will try that again. Good evening. Good evening. Excellent. I see I have very few enemies. I noticed two. And I also noticed one witch. I am quite honored to be here this evening. And I thank a lot of my colleagues who made this possible. Thank you so much, Lynn, for that excellent, very humbling introduction. Now I know who will read my eulogy. And thank you for all the colleagues. I see old faces. I don't mean you're old, I mean old faces as in I knew you from a long time ago. Thank you so much for being here. It's always a pleasure to be back in Seattle. I still treat Seattle as home. This is where I began my academic career, one from which I'm still recovering. And I really, really do miss being in an academic setting. I do miss being in classroom. And so whenever I'm given an opportunity to come back, I'm always very happy to do so. So, I think I'm going to speak for about 40 to 45 minutes. Usually when I start speaking, the spirit possesses me. So what we will do is I will just speak, and when 40 minutes reach, Lynn, you can just give me a sign, because we would have said enough to just stop at that point. And then we can, if we need to continue with the conversation, we can do so during the Q&A period, which is to say there will also be a Q&A period, as Yvette has said. And thank you so much, Yvette, for your really flawless coordination of this visit. It's been really, really humbling and wonderful. So let me begin by asking, how do you guys feel about American democracy right now? What do you feel? I'm trying to tell from your faces. Yeah? You've panicked. Still evolving. Oh, I like that one. Still evolving, and so forth. Okay. Now, today I'm going to talk about transformative constitutionalism. And I know it does feel a little quaint, maybe old-fashioned, to speak about transformative constitutionalism, rule of law, to a US audience. But believe me, there's no better time to be speaking about transformative constitutionalism, about the rule of law, than it is now. And not just in the sense that there are some Americans who feel that we shouldn't be speaking about rule of law because, oh my gosh, good riddance. We can finally start living American exceptionalism where we don't care about rule of law. I don't mean it in that sense. It's a good time to speak about constitutionalism because the times now call for it. And for those of us who have been on the trenches or in the margins, in those ideological places and geographical places that sometimes are called the third world, we welcome you to speak about rule of law with a knowing smile, because we have been there. But the good thing is, I think you need to know that there are ways to overcome. So just before I go too far, I just want to say that there are really three things that I want to, that will be my message this evening as we speak about transformative constitutionalism. And I think these are things that the American audience will welcome hearing. The first one is something that sometimes we forget easily, but it's important to always remember, which is that the work of liberty is never done. It's never done. There is no day you'll go back to bed and say, now we have finished the work of liberty. Tomorrow, we start enjoying it for the rest of humanity. Okay? If you want to know that that doesn't age very well, ask Francis Fukuyama. In 1990, he wrote a book called The End of History. It was a very triumphant one about how the American model of democracy has conquered and will be the end of history as we know it. Cannot be perfected beyond what it was. I don't think that book has aged very well. So we must always remember that the work of liberty is never done. It keeps going. Then the second thing I want to share with you today in the story that I will tell you is one that I think is important to remember even in America today. And we have to remind ourselves in Kenya as well. Our constitution is fairly new, from 2010, which is that the Constitution is always becoming. The Constitution is always being promulgated. it's not an event that just happened once and voila, that's it. I think the mistake sometimes we make is thinking that the organic process of constitution making ends with its promulgation. The truth is, we always are promulgating the Constitution by imbuing new meanings, contextual meanings in our everyday life. And particularly in America today, this is also true in Kenya. By the way, we are having a lot of the challenges that we're having in terms of our governance and political leadership as well in Kenya. It bears to remember that. And then the third and obvious thing that I want to say, which you can glean from my title, is that the Constitution, and particularly transformative constitutionalism, is durable. But it's only durable under three conditions. You must have, one, a watchful judiciary. Two, you must have engaged interlocutors with the courts. They must be enlightened and must be engaged. And three, and perhaps most importantly, you must have an active citizenry. Active in the sense of civic attention, being civically active. With those three conditions, the Constitution can prove durable, and it can prove durable even in moments of ephemeral decline and reversal. And sometimes you wake up in the morning and you feel like we have reversed 100 years, or we've reversed 10 years, or 20 years. You always must remember the transformative constitutionalism is durable enough to overcome those moments of ephemeral decline or reversal. But in doing so, we must remember that complacency is a formidable enemy of the durability of a constitution. An active citizenry can never afford complacency. And so, I will say something I said in class this morning to the students who were in my class this morning, is even as I've been back here in the last 4 days, I have had a lot of very progressive, good-meaning people saying, oh my gosh, things are so bad, but we are so lucky. It's only 4 years. And then we will go back to our normal lives. I want to assure you that it's never only 4 years. That complacency is dangerous. You cannot say it's just 4 years. We will wait and we will pick up after 4 years. I like reminding Americans that in 1978, when I know most of us here were not born, we said that in Kenya. We said that Daniel Arap Moi, who turned out to be one of the most effective autocrats to have ever lived, Kenyans said, it's a passing cloud. Literally, it's just a passing cloud. We don't have to worry too much. It will pass, and we will go back, and we will continue with our constitutional lives. 24 years later, many lives lost, many people disappeared, limbs severed, blood lost. We discovered that it was not a passing cloud. In 24 years, he had managed to build one of the most formidable autocracies on the face of the earth. It was not a passing cloud. And this, too, my American friends, is not a passing cloud. You can't say we will wait because it's only a passing cloud. So we can't afford the complacency. But now, I did promise you that I'm going to talk about transformative constitutionalism. And the transformative constitutionalism I'm going to talk to you about by way of comparison is transformative constitutionalism in Kenya. In the very few short years we've had of our new constitution. Now, so I'm going to talk not just about transformative constitutionalism, but I want to relate it to something that I do now very actively, which is on the question of access to justice. In a minute, I will demonstrate to you why access to justice is important for keeping the democratic experiment going and for keeping the Constitution durable. But I must say that even as I speak about transformative constitutionalism in Kenya, it is not a triumphant story. I'm not going to tell you that I'm speaking about the Kenyan Constitution and constitutionalism because we have triumphed, because it is something that now is worth building a monument for. No. I'm going to tell you the story because it's a work in progress. It's a work in progress, and we all are construction workers. I, for one, am a construction worker. I wake up every morning and I go to that construction site. Okay? And even in that construction site, we are bruised, but not defeated. Wait, is that from the Bible? I think there's a biblical verse that says something like that. We are pressed on all sides, bruised, but not defeated, right? Perplexed, but not abandoned, something like that. Sometimes that's how I feel about working on transformative constitutionalism. And it's okay to feel that way, because that's the only path to progress. Okay? And of course, not very long ago, even when I was teaching here, every time we would talk about these notions of constitutionalism in the United States, especially constitutional law professors from the United States would tell us with a sense of, should I call it superiority? That, yeah, we feel you, that you guys are going through this, but don't worry, you'll overcome. We did that 200 years ago, and now we're okay. Now at least we can say we are all in the same boat. So there is now proper cross-learning. You can learn from us as we learn from you. Not to be flippant about it, I think there's something to be gained from that cross-learning. Now, let me just very quickly just put some ideas on the table that we'll be talking about. And I'm sorry, I forgot to bring my advancer. Now, when we talk about transformative constitutionalism, it's not a mysterious concept, by the way. It is just the concept that the Constitution is meant to bring some widespread societal change. So these are two definitions, luckily, by Americans. Professor Carl Clare is from Northeastern University, and he talks about transformative constitutionalism as an enterprise of inducing large-scale social change. And Carl tells us, introduces the idea that transformative constitutionalism is not about preserving an idealized past, but to point towards an ideal future. That second definition is very important for Americans because in America we have the tendency of thinking about the American Constitution as preserving an idealized past. That's why it begins, these truths are self-evident. Okay? The idea is to preserve a past that's idealized, that is deemed to be perfect. And the Constitution is supposed to preserve that. The notion of transformative constitutionalism goes against that and says, actually, the purpose of a constitution is to point towards an ideal future which we might not even be able to imagine right now. But through our collaborative work and thinking, we are always trying to become it. This is why Barack Obama always used to talk about becoming a more perfect union. This is a concept of transformative constitutionalism. So the idea of transformative constitutionalism is not a text that's in the Constitution. It is a notion that is built about our understanding of the Constitution. And I urge us in the audience, my American friends, to also assume the posture of transformative constitutionalism, because it's an effective way of guarding our democracy as present and as it's emerging to become a more perfect form of democracy. That's just a definition of transformative constitutionalism that in Kenya has now been adopted by even our Supreme Court. That's what I had in that slide. Now, in the Kenyan Constitution, and I'm sure you'll be able to recognize this in the American Constitution as well, there are three critical modalities of transformative constitutionalism. And this will speak to you quite obviously. The first one is civic autonomy, and the important, and I will, in a brief way, I'll talk about the importance of civic autonomy. And the second one is the notion of transformational rights. This might be slightly new to the American audience, but I will demonstrate to you why, perhaps, even within the context of the American Constitution, one can define or can find this transformational right. And then the last one is access to justice, something that I'm very passionate about. All these three notions are modalities that, if not by text, but by context, can be read into the Kenyan Constitution. And I would argue, if you give me enough time, that means 2 days, I can demonstrate to you that they are also present in the American Constitution. You would have realized by now, what I'm really trying to do is to give you hope. Even as I tell you the story of Kenya, I'm trying to tell you that it's not all lost, and I'm trying to tell you that you do not have to wait for 4 years. These are things that can be done right now in the context in which we are in. Let's begin with civic autonomy. What's the critical importance of civic autonomy? The first thing that civic autonomy does, and in a place like Kenya, this was very important, and you will see this will become increasingly important here as well, is that it reconstitutes the citizen in their character as a citizen, so that the citizen is no longer a subject. In the pre-2010 Constitution, we had the government and we had citizens. And the government, the citizens were below the government. The government spoke to the citizen, at the citizen. What the Kenyan Constitution 2010 tries to do is to redo that relationship so that it reconstitutes the citizen. In a moment, I'm going to say what that citizen has. That's the notion of transformational right. What is it that that citizen must have for them to have been reconstituted in a true character of a citizen as opposed to a subject? You'll remember this was an important notion at the founding of this nation, running away from the British idea, the colonialist idea, that there was a government and then the subjects under the monarchy. Then secondly, the importance of a civic autonomy is that that citizen has a voice, can assert that voice. And then thirdly, that citizen has agency. Okay? In a minute, in the area of access to justice, I'll demonstrate why that agency is important. They can act. They can not only speak, but they can act in specific ways that are consonant with their character as citizens. Then now I want to talk to you about the critical importance of transformational rights. First of all, The first notion of transformational rights is that it asserts something that even lawyers in the room will find a little unfamiliar, but I say that it asserts the truism that the state is unavoidably constitutive of the market. What does that mean? It means that the distinction between the state and the economy in our modern world is a false one. It's a false binary. There can be no market without the state. The market, is constituted unavoidably by the state. So every time someone talks about it's a free market, let the free market reign. Every time you hear that, you should just hear that as an ideological utterance and not as a factual truth. It is not a factual truth because the market requires the state, and in fact, in the very first place, was created by the state. So a lot of billionaires, of course, love saying that they love the free market, and because that's where they make their money, they don't need the state. It's the poor people that need the state. I'm here to tell you that that's a lot of baloney. If there was no state today, there would be no billionaire. And the best way to know that that is true, and you'll see why this is important in a minute, the best way to know why that is true is to answer the question, what is property? By the way, what is property? What's property? Many non-lawyers say it's a thing I own, isn't it? Today I want to give you a very radical definition of property. Property is that which the government says is property. It's that which the state, actually not government, state, is that which the state says is property. You think about that. And if you have any questions, we can pursue it a little further. But the state has capacity, out of thin air, to create something called property, and then decide who will own it. I used to tell Kenyans this, and they used to find it very difficult to wrap their heads around. So let me just give you a short story that will demonstrate this. We moved to, we did digital migration of our airwaves in Kenya pretty recently. Okay? Why is that important? That's important because the state had to decide who owns that property. That's in our lifetime. Okay? And there were different, it could have gone in very many different ways. The state could have decided it's community rights, so it's owned by everybody, could have decided that it's owned by the state, and so forth. Instead, the state decided that it was going to give licenses to certain people, okay, including a lot of Chinese companies, to own those rights. What has happened there? The property didn't exist yesterday, but with the policy made, it exists and it's assigned to certain people. And a lot of people became billionaires, by the way. And if you speak with them today, they will tell you about the free market. That is as stark an example as you can ever find that the state is unavoidably constitutive of the market. Secondly, the idea of transformational rights animates the idea that each state must have a credible mechanism for sharing prosperity. Again, this sometimes sounds like a dangerously communist idea. Does it? It's not communist at all. Because the state has created the market, by creating the market, it has already decided who the winners are and who the losers are, then it follows that there must be credible mechanisms for sharing the prosperity that has been created. If there's no credible mechanism for sharing that prosperity, then it doesn't end well. Okay? Either you get an autocratic government that maintains those relations through brute force. You can imagine, you can think about a number of countries where that happens. Or through very effective ideological warfare to persuade the citizenry that, you know what, we've created a lot of wealth, it's owned only by a few people, but don't worry, life is good, it will be better in heaven, so it's okay. That you have to be very effective ideologically for you to do that, or the only third way is you're going to have civil war. There will be complete, total disorder. And then lastly, transformational rights also provide what I call a radical substance to access to justice, also as a way of co-creating autonomy, and I will get to that in the next few slides. Let me just demonstrate to you the notion of transformational rights and why there's much to be done in the United States in this sense. First of all, let me just do a very short detour and demonstrate to you the two dominant dialects of human rights. I know many of you who've done any foundational course in human rights would remember this. In human rights lingua, we say that there are two dominant dialects. The first one is civil and political rights. Civil and political rights are what sometimes are called negative rights, wrongly. Freedom of expression, the right to fair trial, and so forth. Those are civil and political rights. The second one are social and economic rights. Social and economic rights is what you Americans don't have in the Constitution. The American Constitution does not have social and economic rights. Social and economic rights are the right to housing, the right to health, cultural rights sometimes, and so forth. Right to schooling and education and so forth. Now, the American Constitution does not have social and economic rights, but the fact that they're not in the Constitution does not mean they cannot be read in or cannot be treated as fundamental rights. Now, to have transformational rights, I argue that we must even go beyond these two rights. So if you think about these two rights, it will look like this, okay? Continental Europe emphasizes social and economic rights. Anglo-American Constitution emphasizes civil and political rights. So that's why in America, for a long time, we talk about mistrust of government, where the government is viewed more as a predator. So the rights are shields for individuals against the government. The emphasis is on individual liberty and initiative. So we think of them as negative rights. And there, the state is supposed to be promoting markets in every sphere. In continental Europe, the emphasis is the opposite, okay? Where the state is not seen as a predator, instead is seen as a protector of the needy. And then the state limits the range of possible market outcomes. Now, however, to have transformational rights, sorry about that. We go a little deeper than that. So you have constitutional rights, you get democracy defined mainly, at least in terms of perspective, as freedom from the government. You emphasize social and economic rights, you get democracy like the French one, where the government is seen as a protector, as a guarantor of the good life for all. But then, what we had in Kenya in the 2010 Constitution is we have a straddling of those two, where the government is not a predator, and it is not just a guarantor, but it transforms both the state and the society. And that is what I am advocating as amounting to durability of the Constitution. Now, so then what will transformational rights have? At least as can be read if you think about the straddling of both the social and economic rights. It has these qualities. First, it begins with the very radical notion that each citizen has dignity. Why is that radical? That's radical because you'd notice that it's not in the text of the US Constitution. You will not find in the text of the US Constitution that each human being has dignity. Why is that important? It's important because dignity itself has substantive content. Okay? And we will see that in a minute. But then that human being that has dignity also has a voice. They have a choice and ability to participate in civic life. They have guaranteed basic minimum social and economic rights with opportunities to co-create material and social goods, that's culture, but also participate in the marketplace. The notion of transformational rights rejects the distinction that I talked about between markets and states, and as soon as you reject that distinction, a whole range of possibilities of what you can do for different kinds of problems in the society emerge almost miraculously. And in the case of Kenya, this has turned out to be important. Then there are what we call justiciable national values. These are in Article 10 of the Constitution. In other countries, there are directive guidelines, like in India. In some other countries, they are contextually read into the Constitution. For example, in the South African Constitution. But most importantly, and lastly, there is an effective access to justice to enforce these rights, including these transformational rights, and including the justiciable national values. Now, you'd realize that I talked about access to justice and not access to courts. And that's important. Because for the longest time when we talked about access to justice, we assumed that access to justice means access to courts. That is why the rule of law reforms that have been undertaken throughout the world for the last 60, 70 years, I think they started in the late 50s, right until now, all rule of law reforms assume that any rights that are violated or any grievance that the citizens have will have to be taken to court, and that is where they will be adjudicated. Access to rights, access to justice, as I'm defining it, means just access to just a form, a place, a forum where your grievances will be adjudicated effectively from your point of view. You do not have to meet a magistrate. You do not have to meet a judge. You do not have to meet a prosecutor, but you have your access to justice. That framing is extremely important. So if you want to know the importance of framing, I remember, let me just give you a short story so that you can wake up. So those of you who've been sleeping, it's time for waking up, time. The importance of framing, access to justice versus access to the courts. I once met two professors who were married to each other, and they seemed to be, they had been married for more than 40 years. They looked genuinely in love. That's very difficult after 40 years. So I asked the guy, tell me, what's the secret? You seem to have been very happy for all those years. And he told me, oh, believe it or not, we have a very traditional marriage. That's what keeps it happy. I said, oh, how so? You don't look like it's traditional. I said, well, when we got married, we made one rule. That rule was suggested by my wife, and I happily co-signed. The rule was, in this house, I, as the man, I get to make all the important decisions. And then all the other decisions, the wife will make them. I said, oh, that does sound not only traditional, but a little problematic. He said, yeah, but that is the secret of our marriage. I said, okay. He said, you know the most interesting thing about it is, in the last 40 years, there has never been an important decision in our lives. That's the power of framing. So yes, you can make all the important decisions, but there are no important decisions. In other words, she gets to make all the decisions. So it seems, in terms of framing, like a fairly traditional marriage, but it's anything but traditional. Now, allow me, as I head towards the end, in the last few minutes, to speak about access to justice and why access to justice is important, and how we've interpreted access to justice in the Kenyan Constitution, and why we believe it will lead to the durability of our Constitution. First of all, the critical importance of access to justice. I want to speak to you about two important aspects of access to justice. First of all, access to justice has recently been recognized as very important, including in SDG goal number 16, which now adopts specifically the language of access to justice. It's important because, in the first place, it is an enabler and a facilitator of all other rights. If you do not have access to justice, you really can't have any of the other rights. So you can think about all the people who do not have access to justice. It just means they have no way of enforcing any of the other rights. But also, access to justice is important because it facilitates a discourse and justice conversations, including the conversations about shared prosperity, which sometimes is a very difficult conversation. And remember, I started by saying, when, first of all, you have a sharp distinction between market and state, this becomes a very difficult conversation to have, because immediately you start having it, the word redistribution rears its head. And people start saying, the government has no right to redistribute from A to B. The next time you hear that argument, you must remind them that, in fact, the government is always redistributing. In fact, the government already redistributed so much to the billionaire. And all it's doing is trying to establish a little bit of an equilibrium. Access to justice as a discourse enables that conversation to take place without using sloganeering, or without sloganeering becoming the ideological trope. Now, this is a beautiful quote from Desmond Tutu, which I think frames what I really want to say about that, which is that there comes a point where we need to stop just pulling people out of the river. We need to go upstream and find out why they are falling in. If you're working downstream all the time, serving underserved people, adding more resources there, adding more people to serve, finding a little bit more money and so forth for them, then basically what you're doing is you're pulling people out of the river downstream. But the conversation must begin upstream. You must go upstream and find out why are they falling in that river in the first place. You only do so when you breach that sharp distinction between the state and the market. Now, there are two aspects to access to justice which I want to put on the table, and then I will briefly talk about alternative justice systems and its relationship with access to justice. First of all, access to justice can be viewed as an emancipatory jurisprudential discourse. What access to justice in part does, it allows us to overcome what I call the fetishization of technical justice. And in Kenya, we had a lot of that in the pre-2010 period. In the United States, we had a lot of that. Because sometimes it's good to talk about the past so that those who are alive can feel okay and comfortable. In the United States, if you think about how the law was interpreted, and especially the Constitution was interpreted, between, for example, 1850 and 1937, those of you who've done constitutional law will remember what happened in 1937, when finally the New Deal legislations were allowed to have their sway by the Supreme Court. That was formalist jurisprudence. That's fetishization of the technical. There, what was being fetishized was the idea of substantive due process, if you think about it doctrinally. So the idea of fetishization of the technical justice many times comes in the way of access to justice, substantively. And Kenya, of course, was no exception. Just to give you an example, we have this famous case of Kamau Kuria versus Attorney General. I just want to demonstrate to you what fetishization of the technical is. Gibson Kamau Kuria was one of the foremost human rights lawyers in Kenya, fighting the dictatorship of Daniel Moi. And in 1989, he was nominated to win the Robert Kennedy Award in New York. So he wanted to travel to New York from Nairobi to go and receive his award. When you're going to travel from Nairobi to New York, you need something, right? What do you need? Well, you need a visa, thank you. But before the visa, passport. You need a passport, isn't it? So Gibson Kamau Kuria went and applied for a passport to the immigration department. Okay? Remember, you had become a human rights defender because of criticizing the government of who? Daniel Moi. And the immigration department belongs to the government of who? Daniel Moi. And he's going to get a passport to travel to receive an award for criticizing Daniel Moi. And I can imagine the conversations that were taking place between Moi and the minister in charge the evening before. So obviously, he was denied the passport. So Gibson Kamau Kuria, being a good lawyer, went to court, went to the High Court. And he asserted his right to travel, freedom of movement, which was, by the way, in the Constitution, in the pre-2010 Constitution as well. So it went before a High Court judge, and I can imagine how hard a time that judge had, thinking about Moi on the other hand, and thinking about intellectual honesty and the Constitution on the other hand. Suffice to say that the judge came up with what to him must have been a genius answer. Because he read the Constitution. I remember probably the night before, he must have read it very studiously. And he found in then Section 84, subsection 10 of the Constitution, this was the Bill of Rights. This was a section that said how the Bill of Rights, the freedom of movement was part of the Bill of Rights, would be enforced. He found a subclause that said, the Chief Justice may make rules for effectuating this Bill of Rights, like make rules how people will approach court. So the judge said, voila. Mr. Gibson Kamau Kuria, I am so sorry. I would have been very happy to help you, but I have a very small problem. The Chief Justice forgot to make the rules, which would have allowed you to come to court. And because there are no rules, I cannot enforce the Bill of Rights. Do you see what he did there? The Bill of Rights is part of the Constitution. Those are rights that are entrenched in the Constitution. The language of coming up with rules for purposes of enforcing them is couched in permissive tones in the Constitution, which just allows the Chief Justice to make rules just to make sure for the orderly running of the courts. But that became the reason why the president, Gibson Kamau Kuria, could not enforce his constitutional rights. That's an example of fetishization of justice. Another example, just so that this can reach home on this fetishization, and it's important in America today to really think about that, because you're seeing a lot of these cases coming before the courts, right? You're seeing all these courts about the Alien Enemies Act and so forth, and they're coming up for reinterpretation and so forth. Read them with this in mind. So in 1992, we had the first multi-party elections in Kenya after a very long time. And one of the most formidable opponents of the president was a man called Kenneth Matiba. Unfortunately, by the time he was running for president, he was paralyzed on his right hand. By the way, he was paralyzed while he was in detention without trial by President Moi. He thought he had won the elections, so he petitioned the High Court, as it was then allowed, challenging the election of President Moi. So the case came before 3 High Court judges. 2 of them, by the way, are still my colleagues now. And I can imagine the terror they must have had trying to decide how to decide this case. Until again, in a stroke of genius, they discovered something. They looked at the election petition, and the election petition had one rule that said, in order to challenge the election of any person, you must present a petition, and that petition must be signed by the petitioner, must be signed in person by the petitioner. Did I tell you Kenneth Matiba was paralyzed on his right-hand side? And he could not sign. So what did Matiba do? He donated his power of attorney to his wife, and his wife signed on his behalf. It went before the 3-judge bench. They looked at it and they said, we would really have wanted to help you, Mr. Matiba. But it's right here in the Election Act. It says that you must personally sign. This one is not personally signed by you, is it? This is signed by your wife. And therefore, we must throw out your petition without looking at the substance. That is another example of fetishization of technical justice. So they say, we know you're paralyzed, but unfortunately, we can't help you. We can't help you because the terms of the law seem very clear to us. So one of the important aspects of access to justice is that the discourse of justice must avoid this fetishization of the technical and instead have a substantive bite. Now, because of some of these problems in the Kenyan Constitution 2010, we included a very particular clause in the Constitution that says justice must not only be done, but it must be served in a way that avoids technical justice and pays attention to substantive justice. Now, unfortunately, we don't have that in the American Constitution, but hopefully it's something that can be learned contextually. The last point I wanted to make is this second modality of access to justice, which is access to justice as a modality of processing grievances between individuals in the society. Why is this important? This is important because, as I told you, Kenya, for example, has been going through rule of law reforms for many, many years. Literally, hundreds of millions of dollars has been poured into these rule of law reforms. The ultimate ideal of a rule of law reform is that an individual who gets a grievance then will be able to process it through the courts. And that has been the focus for many, many years. Now, when I was appointed chair of, at that time, the task force on alternative justice systems, what the judiciary was trying to do was to look at a particular sub-article in the Constitution that says the judiciary shall promote alternative forms of dispute resolution. And we wanted to find out what exactly does that mean? What did Kenyans mean when they included that in the Constitution? Now, we did a survey in Kenya, what is called the Justice Needs Survey. And the results were very sobering. This was in 2017. We were trying to find out when Kenyans have a grievance. When you have a grievance, then you need a place to process it, right? When you have a place to process it, that's what's called access to justice. So we asked Kenyans, what do you do when you have a grievance? So 19% of Kenyans told us they do nothing. That number is frightening. That's 19% of people who are sitting at home with grievance. I suspect it's much higher in the US right now, temporarily. But you imagine 19% who have a grievance, and they look at their situation and they decide, I will do nothing. Okay? Because Kenyans tend to be, I was going to use a bad one, very Christian. These are the ones who resort to the Bible and they say, even the Bible says, the vengeance is mine, says the Lord. Okay? Romans 12:19. So they do nothing. That's a very, very frightening number because it means these are people who have no access to justice. That means it's people whose livelihoods are endangered, they have nowhere to go. That means these are festering wounds in the soul of the polity. But look at this. Only 17% go to court. Okay? Now, I can tell you, when I left UW 13 years ago, I had no single strand of white hair. Those of you who know me will remember. And right now, almost all my hair is white. Do you know why? That's because of backlog. We absolutely cannot deal with the caseload that we have. In Kenya right now, our backlog, that means cases that are 3 years and older, are 658,000. Okay? If you subdivide that number with the number of judges and magistrates in Kenya, it's about, each one of us has 1,500 cases. So even as I give you this talk, I have 1,500 cases, hypothetically, waiting for me to decide. 1,500. On average, a Kenyan judge or magistrate, on average, clears about 350 cases. So how long will it take for me to clear my backlog, my quota of backlog, 1,500? If you do simple maths, it will tell you about 4 years, isn't it? That's assuming no new cases are filed, right? And last year, 23% more cases were filed than the previous year. So we know the number of cases being filed are actually increasing, not reducing. Yet, the sobering figure is only 17% of Kenyans are filing those cases in court. Isn't that frightening? So I always remind my colleagues, even as we are struggling to write our judgments at night until midnight during leave and so forth, we're only dealing with 17% of the case basket of all cases in the country. Here is a hopeful figure. 64% of them go to alternative justice system. That's both hopeful and troubling. It is hopeful because 64% of Kenyans who would otherwise not have access to justice have access to justice. It's troubling in two senses. It's troubling because for 60 years, we've been pumping millions and millions of dollars into the institution that only decides 17% of cases, and have done nothing about the institutions that decide 64% of the cases. Do you see, from a public policy perspective, why that's problematic? But it's also problematic because we absolutely have no clue how this justice is being processed in the 64% of the cases. Do you see why that could be troubling? We have no idea what kind of justice is being served. Is it justice that's in keeping with the constitutional minimums in the Bill of Rights or not? Is it justice that's in keeping with the procedural rights of the people or not? So basically, we proceeded for all those years, pumping all those millions into courts without knowing what's happening with this 64%. So we have three very troubling figures. It's 100% divided into three categories, and they're all troubling. 19% is very troubling because, oh my gosh, what are these 19 people doing? And remember, if they have no access to justice, there can be no sustainable development. There can be no economic development. There can be any kind of development if 19% of your population has no access to justice. 17% is very troubling because, oh my gosh, for all the work I do, I only deal with 17% of the cases, but I gallop 100% of all resources. Right? That's a public policy nightmare. And then lastly, 64% is troubling because I really have no very good idea what kind of justice is being received there. Is it gender sensitive? Is it not? Is it anti-women? Is it anti-persons with disability? What kind of justice is there that is being received? So that is when it became very clear to us that Kenyans had a very good idea on two things. One, in Article 48 of the Constitution, they talk about access to justice and not access to courts. It turns out that's not a product of cognitive confusion. They knew exactly what they were saying. They wanted Kenyans to have access to justice and not necessarily access to court. Which means Kenyans trusted themselves. They knew how they're resolving their cases, the 64%, and they trusted themselves. They trusted in their own agency to be able to decide those cases. That is despite, as I said, more than 60 years of official neglect of these mechanisms that have been durable enough to decide those cases for all those years. But secondly, it also now became clearer why in Article 159, 2C of the Constitution, Kenyans say the judiciary, in administering justice, the judiciary shall promote alternative justice system. Shall promote. Two things are important there. First of all, it's a commandment to the judiciary. It is not a request to the judiciary. It's a constitutional commandment. That's what shall means when it's used in the Constitution, directed at a duty bearer. But secondly, the word promote is actually plucked from human rights lingua. For those of you who are students of human rights, will recognize promote is from human rights language. So it meant that the judiciary needed to do something. You can't just sit and say you're promoting. There's something that the judiciary is supposed to do. This is why the Kenyan judiciary formed the task force and now the committee that I head to try and figure out what does promote actually mean. And especially when you look at these three figures. So to end, let me just say, in Kenya, we now found that for the judiciary, it means three things. It means that, first of all, there is a duty to respect alternative justice systems. And believe it or not, to a lot of lawyers, that's radical. Because lawyers believe, just this morning I was talking to law students and I was telling them, you know, when you go to law school, one of the things that they very quickly do, I told my students, what law school teaches you is that the language of the law and the method of the law is the most powerful invention by man. And so immediately you learn how to use it, it feels that it's the only way that societal problems can be resolved. That is why lawyers have a very difficult time understanding when you tell them, actually, it's there in the Constitution. It says that the judiciary must respect alternative justice system. Because they look around and they say, if it's not we lawyers, we judges, we magistrates who are to solve this problem, then who? Who else? And the answer is, people have been resolving those problems for hundreds, thousands of years successfully. But the second thing it also means is that there is a duty to protect alternative justice systems. Again, a very radical idea, especially for judges and magistrates. Protect. That means, respect means you do no harm yourself. Protect means control third parties who are trying to harm alternative justice systems. So an active role for the judiciary. But thirdly, and this is perhaps the important part for human rights activists, workers, scholars, is the duty to transform. So the judiciary is also given a duty to transform those mechanisms, the alternative justice systems, the mechanisms and their practices, which then means the judiciary now has an active duty to not only deal with the 17% of cases that come to the docket of the judiciary, but the judiciary must go out and make sure it has figured out what happens to the 19% of the Kenyans who have no access to justice. It's part of the duty of the judiciary. And then thirdly, the judiciary also has a duty to figure out what is happening in the 64% and ensure that the justice that is being served in that 64% is in keeping with the constitutional minimums. All that becomes part of the role of the judiciary. Why is that important? That's important because then we start heading towards a country where there is the justice gap is progressively being eliminated or being removed. 19% would be the justice gap in Kenya, for example. But it also means that you are heading to a country where you're heading to about 100% access to justice, which means then you're creating the active citizenry that is needed, which is an important foundation for the durability of the Constitution that I talked about. I would like to stop there because I think we've said enough. We've said enough. We've put enough on the table to answer any questions. I hope one of the questions is going to be, please proceed. Thanks. I guess I should just stand here and continue answering? Okay, good. Thank you.
So you're welcome to come to the microphone and ask a question. We have about 10 or 15 minutes for questions. So there are a few that have already come in on the Slido. So a couple of them, I think, are pointing to the same issue. Asking you, so you referred to the role of Daniel Arap Moi in Kenya and that time, which was a very repressive time for human rights and democracy in Kenya. So people are asking, what lessons could people in the US take from the fight against that authoritarian rule in that time period for our situation today in the US? So, so that's one question. And then people want to know more about what the alternative justice systems look like and how the judiciary can promote them. So I'll stop with those two.
You can start with those.
Yeah.
Lessons from Moi regime. I guess the first lesson is that never give up, really. I would tell you that there was a time I became of age during Moi's time, and the rulership under Moi was so total, we couldn't even at home mention his name. If you mentioned his name at home, your parents would beat you up. They would tell you, do you not know that these walls have ears? It was that total. One of the things that we learned from that, and it took me a little bit of time to realize, was that people kept fighting back. Even when it was obvious they were going to lose, they kept fighting. They kept doing their activism. They kept filing the cases. It is not that Gibson Kamau Kuria did not know that he was going to lose his case in the High Court. He still filed it. Okay? After that, Maina Mbacha filed his. After that, Paul Moite filed his. Okay? It is not that William Mutunga, who later on became the Chief Justice in Kenya after the 2010 Constitution, did not know that there was no right to bail in Kenya under the previous Constitution. He still went to the High Court and said, I need my right to bail. Why? Because you are creating a record. Why? Because every effort counts. Every effort becomes part of the collaborative and solidarative efforts towards change. And eventually, that's what brought the change. It is the fact that every effort matters, every step matters, and you just have to keep moving, and you cannot be complacent. You can never say, we will wait until he dies. In fact, that's what someone said. Someone said, oh, the good thing we have in America is that old people die. You can't be complacent, and you can't say, we will wait. You have to keep fighting. Every effort counts. And of course, the second thing, obvious thing, is that lawfare does matter. A lot of the changes we saw in Kenya, which eventually led to the 2010 Constitution, were really through lawfare. Filing cases here, insisting on a particular interpretation there, engaging in the next place, and so forth. And eventually, again, that adds up. Earlier this morning, I said to the students, that one of the things that we have to learn in the new world, and it's really to learn, because many of us have now grown up in an age where a lot of the things seemed, a lot of the bad things that we used to read about that used to happen in the 30s and 40s seemed so remote, like they would never happen to us. And now one of the things we have to start learning is that, yes, they're happening to us, and we have to join in the fight to try and change them. And being inactive is not a choice. But we must also learn that that triumph, that victory, will not come within a day. And we cannot wait to put our efforts when we see that the horizon is nearby. So now we wake up that day. I always say, and those who've been my students will remember this, that the revolution will not happen tomorrow. The revolution happens today. With every step that you take, with every action that you take, to resist unlawfulness, to insist on the right procedures, to insist on human dignity. Every step you take, that is when the revolution will happen. And it is when all those efforts put together will lead to that eventual change that we all hope to see. Access to alternative justices, what do they look like? So when we went to Kenyans, first of all, I want to say that what is contained in the alternative justice policy in Kenya is not an invention of my committee at all. All we did was actually to do an anthropological study of how Kenyans were resolving their disputes. And we put it together in a policy. And when we did so, we found that Kenyans have mechanisms that are in three flavors. The first flavor is what we call autonomous alternative justice systems. Autonomous means they are not affiliated with any government institution, with any NGO, with any CBO. It is people just come together and they resolve their justice needs. Just like that. In the villages, in the estates, in the churches, in the mosques, people just constitute themselves into alternative justice mechanisms. And they decide their cases. And they never go to court. And it's good enough. So one of the things people kept asking us is, like, okay, so then what should we do with these guys? And by the way, it's a majority of cases that are decided. A lot of the resolutions happen in this space, in the autonomous space. So what should happen to them? And our answer was very simple. If it's not broken, don't fix it. Right? Kenyans are resolving their disputes happily. Our task cannot be to go and start saying, oh, we see you've been resolving your dispute, but can we add you these 9 forms now which you should be filling when you decide your cases, and then you come and report to court? Because the Constitution allows them to resolve their cases. They don't have to be reported to anybody. Please continue deciding your cases. Please, in fact, decide more. Can you take some of the 17% also and decide them? The second flavor of alternative justice systems is what we call third-party annexed alternative justice systems. So these are either, they come again in 2 more flavors. There is government institution annexed justice systems. So you'll find a lot of government offices, administrative chiefs, assistant district commissioners, children's departments, probation department, and so forth. They also constitute alternative justice systems to resolve local problems and local disputes. So the government entity becomes the convener of these alternative justice systems, and they decide very many cases. And again, we said, as long as they're being decided, it's good and it's okay. The second flavor of a third-party annex are those that are annexed to NGOs or CBOs. So CBOs, for example, notice that there is a lacuna in an area, and they constitute alternative justice systems. They become the conveners of those. And those, again, we found to be quite okay. The last one, which is a fairly new invention after 2010 Constitution, is what we call court-annexed AJS mechanisms. So these are convened and constituted by the courts, mainly through the Court Users Committee. But sometimes they look at repeating the repeated nature of certain cases, and they decide that perhaps we need more thoroughgoing solution to the problem that is being manifested, for example, in a particular kind of crime. And they find that alternative justice systems become a better way to resolve some of those disputes. For those of you who might be thinking of doing your PhD in this area, there's a very interesting story out of a place called Othaya. And Othaya is, that story is actually important. I'm just thinking about it now because it's related to UW, because that court was headed by a Beara fellow from University of Washington School of Law who got her LLM here. And the important thing about that story is that there was a time we had a very big problem. Those of you who studied Kenya, Lynn, I'm sure you remember the Mungiki menace in Kenya, militarized youth in Kenya, and this area had a particular problem with this. The minister in charge of interior security at that time, his name was Michuki, decided that the way to deal with the militarized youth was to shoot and kill them on sight. So he gave an order to the police that if you see Mungiki, and how do you see someone who belongs to an organized youthful gang? How do you know that they belong to it? So the description they gave is if you had dreadlocks, it meant you belonged to Mungiki, and especially if you were more than two congregated in one place. So they just shot a lot of young people and killed them. Well, that solved a Mungiki problem in many places, because surely dead people cannot form gangs. But in Othaya, through the Court Users Committee, they introduced the alternative justice system, which solved the Mungiki problem without resorting to killing them. It's one of the most durable and beautiful stories about alternative justice system. That's an example of a court-annexed AJS. Thank you.
Maybe time for one more question. This question relates to the recent protests and unrest in Kenya. So I guess going back to last July, would you say that those were a result of limited access to justice?
Oh, I should answer that quickly so that we can get one more question. No. No, it's not per se a problem of access to justice. In my view, it is a demonstration of access to justice. Not in the way the police responded to it, but the fact that the Gen Zs in Kenya felt confident enough to go to the streets and question the government, and almost brought the government down. They almost achieved something that those of us who grew up under Moi never achieved. Was, to me, a demonstration that our Constitution was working brilliantly. And the fact that those who were taken to court, by the way, those who were taken to court, most of them, for different offenses and so forth, most of them were acquitted. And many of them were found guilty of very minor offenses and discharged under a particular section of the Constitution. In my view, that was a demonstration that not only the Constitution works, but there is access to justice. Now, it's a different question how the government responded to these patriotic Kenyans that came to the streets to petition the government, exercising their right that's in the Constitution. Yes.
I was wondering if you would say anything about freedom of the press in Kenya and how that affects how you've communicated these stories about your new constitution.
All right. That's an important question. By and large, I would say there is very robust freedom of the press, freedom of information in Kenya. But I will be very quick to add, that is mainly because of the availability of social media. Kenya is, in terms of internet penetration, believe it or not, I was reading statistics that showed that it's higher than the United States because of something called M-Pesa. Have you guys ever heard of M-Pesa? So for majority of Kenyans, you can access internet from all the different parts of the country, and sometimes very cheaply. And many people have access to that because of M-Pesa. This is how most Kenyans handle their money, is through M-Pesa. And therefore, the internet penetration is quite high. And therefore, people are able to communicate very effectively. This is how Gen Z protests happen simultaneously in many, many towns across the country. Having said that, we, of course, face the risk, which is also apparent here in the United States, of mainstream press being particularly vulnerable to manipulation and intimidation by state agencies. In Kenya, it's particularly effective because most of the mainstream media companies rely on the government for advertisement. That's how they make a lot of money. It's a very lazy way to be a mainstream press, but that is the truth. So if you make majority of your money from the government, it follows that you will have difficulties publishing certain stories against the government, because then they can just withdraw and give the other guys who are not publishing that story, which means you'll stop publishing those stories as well, because the other guys will beat you. So that's a problem that we have in Kenya. Having said that, just a month ago, there was a case that was decided by the High Court that quashed a decision by the minister in charge of information to publish certain government vacancies and information only in one particular newspaper. So that's a welcome relief, because this was found to be unconstitutional for discrimination. I see there's one last question.
Thank you so much for the presentation. It was very nice. And my question is on the conflict between the constitution and the political class. I think that is a discussion that needs to come out, because we have seen a lot of, even in Kenya, you are in the BBI case and all that, yes. But we have seen the political class trying to amend, do all kind of things to the constitution, and that is going to happen, and it's going to continue happening. So are we like, should we rely fully on the judiciary to protect this constitution? Because the population, like, even looking at Kenya, it's very easy for the political class to manipulate the population, and the Kenyans to just like do whatever the political class is saying. It's very easy for that. That happens a lot in politics. And when you are deciding the BBI case, there was this issue to do with the basic structure doctrine. I know, yeah, it's an Indian doctrine. There were a lot of arguments about it, and by you. Yeah, so maybe you can talk about how are we going to protect the constitution from the political class, and is the judiciary our final avenue of hope like they are going to protect the constitution, because I feel that we should not just be saying the judiciary is going to do everything protecting constitutionalism. Thank you.
Excellent question, and thank you for that. I suspect you are Gen Z from Kenya. So there's a lot to say about that, but let me say this very brief, rapid fashion. First of all, the Kenyan constitution is unique in the sense that it has its own mechanisms for defending itself. And that was a brilliant choice by Kenyans. Kenyans knew for a fact that the political and economical elites in Kenya will try to undo the constitution. So the Kenyan constitution is one of the first that was passed without the active support of the political ruling class and the economic ruling class. They were aligned decidedly against the constitution. Well, you can add the church as a third to that. So you can imagine the political class came against this constitution. The economic class came against this constitution. The economic class, of course, came against this constitution because of what I was talking about. The constitution now sees the false facade of the distinction between the state and the market, and makes what people call redistribution a constitutional commandment, actually. So, of course, the elites, the economic elites, would be terrified about that. The political elites were terrified about that because of the way power was diffused in the constitution, and feared that they were going to lose their stranglehold in the constitution. Well, the church was opposed to the constitution because they feared it will allow abortion. It was that simple for the church. Yet, despite the political elite, the economic elite, and the church coming against it, it passed by 67.8%. Isn't that remarkable? That tells you that Kenyans truly wanted that constitution. But of course, these three musketeers never went to sleep. They have been plotting day and night to amend, change, subvert, overhaul that constitution. This is in part what led to what he was talking about, the BBI judgment. Now, what we did in the BBI judgment, in my view, was just to read to Kenyans what their constitution says. And what their constitution says is that you pass this constitution through your sweat, your blood. Some of you lost their lives. Some of you lost your limbs. Many of you lost your liberty so that you could pass this constitution. And in doing so, you put very clear conditions which must be met before this constitution is fundamentally changed. So this is where basic structure comes in. Before it is fundamentally changed, there are certain things that must happen. We were just reading the Constitution in context. And what the Constitution says in context is, if you are going to fundamentally change the Constitution, which came to pass after these 20-something years of struggle, then you must recreate the conditions upon which it was passed. If you can recreate those conditions, and there are 4 stages, if you can recreate them, then good luck. Go and change the Constitution. That's, to me, all that the basic structure doctrine says. And it's something that one can read directly from the Constitution. So is it the judiciary protecting the Constitution? No, it is the Constitution protecting itself. Okay? I like to think of it like that, first of all, because it makes me sleep very well at night. Okay? And secondly, I like to think, if that is the truth, then surely even the government will find it futile to target me. Because any other judge that will come will still read it the same way, isn't it? So it is the Constitution itself that has barricaded itself, knowing too well the challenges that it will face. So the Kenyan Constitution, by the way, it's one of the few constitutions in the world, probably the only one that I know, that has its own theory of interpretation as part of the Constitution. So Article 159 and Article 259 of the Constitution of Kenya, and then Article 23 regarding the Bill of Rights, actually gives us the theory of interpreting the Constitution. It's not like in the United States where you come up with a theory and then someone says, oh, that's a textualist theory, where does it come from? In the Kenyan Constitution, it is in the Constitution. So I get very amused when people say, but does that make you an activist? I'm like, yeah, but it's the Constitution that called me an activist. So deal with it. It's there in the Constitution. I don't even have to invent it. So the Constitution has defended itself, and it will continue defending itself. But ultimately, the only reason judges can have the confidence to make the decisions that they do is because they know they have the people behind them. So it also takes the active citizenry. When the citizenry is active, then those progressive readings of the Constitution become possible. Thank you. Is it a good place to end?
Yeah.
All right. Thank you very much. Thank you so much for your kind listening.